Right, everyone, welcome back to what's now edition 6 of the legal lowdown on the lockdown. We're now moving to a world where there is no lockdown, but there's still quite a bit of legal maneuverings around the response to COVID-19. So I'm here with my colleagues. Just to introduce myself, I'm Geoff McLay, Professor of Law at Victoria University of Wellington. It's been my privilege to be chairing these sessions during stage 4, in stage 3, and now in stage 2 or level 2 of the lockdown. And I'm with my colleagues who have been with us all along, Nessa Lynch, Eddie Clark, and Dean Knight, who are all academics, colleagues of mine at Victoria University of Wellington's Law School. What we're going to do today is hopefully a bit of a shorter legal lowdown, focusing on just a few points that have arisen in the last week or so. We do hope to come back for a 7th and final episode next week, where we'll talk perhaps a bit more reflectively on the whole legal response to the coronavirus and to COVID-19, and what lessons we might at that stage be taking from what we've done or what we haven't done in terms of the law over the last couple of months. But this week is more of an update in terms of what we've been doing. And what we're going to do is just start with Nessa, because Nessa's been at the end of our presentation, which is really unfortunate, because actually where the rubber hits the road in the rule of law is actually when we actually enforce things and actually prosecute people. And Nessa, with other colleagues, notably Yvette Tinsley, has been looking at how courts are actually running under the COVID environment. In particular, we've now got new protocols. The courts and the Chief Justice and the heads of bench have been very active in terms of articulating what will happen at the various levels. And they've got a new lot of protocols for level 2. So Nessa, do you just want to tell us what those protocols are and how they're different from what's gone before, and perhaps how they're different from what we normally do?
Yeah, kia ora, Geoff and audience. So this has been a theme we've talked about throughout. So obviously there's been different protocols ranging from the very restrictive activity under level 4 to the courts opening up more under level 3. So under level 2, we're seeing the machinery of the criminal justice system crank back into operation, but obviously due to the social distancing, physical distancing that we're all living under, there are still many restrictions, meaning that there is going to be quite a backlog. So we explored the issue of the jury trials, which are on hold for many months to come. But it means that the business of justice is quite slow at the moment. So AVL, the audio-visual links, will continue to be used for many defendants and offenders appearing for sentence. And we've discussed in previous weeks some of the human rights issues that may arise there. So obviously one has the right to be present at one's own trial and present a defence. So that doesn't mean that remote participation is ruled out, but there may be many issues in terms of being able to follow proceedings, and also issues in terms of assessing the person's demeanour. As we all know from this world of Zoom meetings and Microsoft Teams meetings, you don't have that same in-person assessment that you can make as usual. So the restrictions on the courts that are in operation also mean that you don't have the same facility for supporters to attend. And so some of the advancements that we've made in recent years have been around the provision of cultural reports, or more ad hoc cultural reports, which are essentially supporters, so family whānau, speaking up from the back of the court for the person. And so the protocols that we have at the moment require that family members approach court security either by email or on the day to receive permission to enter. So Yvette and I have a piece out in Newsroom today which makes the point that that can be quite exclusive. So people need to be able to know those procedures and be able to take days off work, etc., to attend court. So we've also seen obviously many of the out of court processes, such as family group conferences, restorative conferences, even psychological and psychiatric assessments have been affected. So there will be a knock-on effect. But I suppose something that we may pick up in a bit more detail next week is around this conversation we've all been having in ways of working, and what parts of this pandemic response do we want to keep and what parts do we not want to keep. It's certainly a conversation we've been having in relation to teaching. There are many innovations we've tested over the last couple of weeks that we'll be taking into the future, but there are other things, notably in-person teaching, that we can't wait to get back to. So I think there's a similar process in court. There are some meetings that definitely could have been an email or a Zoom or a phone conference, but we do not want to lose those aspects of our justice system that are best done in person. There's also some big lessons around resiliency and resourcing of courts. Even after this pandemic, we're a little shaky island at the bottom of the world. There are going to be other emergencies. Wellington, probably an earthquake at some stage. So there are lessons around having those procedures technologically and spatially in place so that we're ready if there is another crisis, but we don't want AVL and remote participation to become commonplace. So I think in terms of your invitation to discuss those broader issues, that's something that we will be considering in the medium to long term.
You know, and I think certainly from our own professional experience at the university, that while we've all enjoyed some aspects of digital interaction with our students, it's nowhere near what we would expect. Now, just our personal experience has probably been that what we're really missing is that thing you get from face to face. You find out what's really going on. And I suppose that's going to be interesting what the courts come up with in the future in terms of how they mitigate those risks. I know that the defendants often want to be physically in front of a judge because they want to be seen. They want their relatives with them. They want their supporters with them, and it's just not clear. And I think the really good thing that you and Yvette have been making clear is that we just shouldn't let a crisis change what we've been doing anyway, what we're trying to do better anyways. And that's involve people's community, and we shouldn't let this distract from that. Just in terms of this, we talked a lot last time about the search powers in the Act, and we probably won't come back to those till next time, but one of the really interesting things we were complaining a little bit about, that politicians often don't focus enough on search powers or coercive powers of the police. But there was another example, which is bang smack in your research area this last week. So we just thought it would be appropriate if you just outline about the controversy over the facial recognition and the police's use of it. It's not a COVID thing so much, but it's definitely bang smack in what you've been working on the last year.
Yeah, thanks, Jess. So I suppose just to lead in on some of the, I think, basis of this, that how it is a bit related to COVID, is we've talked so much in the past weeks about compliance, and I suppose what restrictions on their freedoms that citizens will accept in the face of a fearful and dangerous situation like COVID. So for those of us who are involved in research around strict state surveillance, these past months have just been fascinating in terms of how or whether the social license relating to surveillance has changed. So for instance, Eddie and I had a coffee yesterday. We probably needed to sign in about 3 or 4 times just to have a cup of coffee and enter another building. That would probably have been unthinkable a couple of weeks ago, but we seem to be relatively willing to accept that. And so something that we might pick up on next week is obviously this COVID tracing app. So we've seen that there's really been some real changes around people's acceptance of surveillance and recording, which wouldn't have been there more recently. And so, as you say, facial recognition landed back. I've been involved in a large research project with some Victoria colleagues and some international colleagues. Like other research projects, it's been on a bit of a hiatus in past weeks while we concentrate on other things. But essentially what happened was it was found out led by Radio New Zealand, that the police earlier in the year had been testing a quite controversial facial recognition system called Clearview. So Clearview is an American-based system, so it essentially scrapes public databases such as your public Facebook profile, and then it sells that as a system where you can run suspect images through that. So it's been incredibly controversial in the United States. So many issues are been thrown up by this OIA. For instance, the police unit that was involved apparently did not run this by their own superiors. They did not follow the usual process for a test like this, which would be a privacy impact assessment process and consultation with the Privacy Commissioner. So I think selfishly, it's really nicely demonstrated the importance of our research, because we are at the moment looking at what are the proper legal and ethical perimeters for the use of facial recognition, because it does fall between a number of stools. We have a lot of legislation in relation to things like fingerprints, DNA, and other personal details, but the collection of facial images, particularly in public, is really a bit of a Wild West at the moment, and this has clearly demonstrated that. So it was really good to see that even in the middle of a pandemic, there was political. So our Prime Minister expressed, I think, that she would have liked to have line of sight on this particular test, which might raise some other separation of powers issues. But good to see that there was political and public concern about this, and certainly watch this space for our report on this later in the year.
So did you have any sense why the police who were involved in the trial didn't think it needed to be put up the line? Because like, I know very little about facial recognition, except that I had heard the podcast criticism of this in the New York Times Detail, which, if anybody's listened to that podcast, it does raise some very serious doubts about some of the people who are running Clearview. And so I just wonder whether, is it just one of those things where the right hand was not talking to the left hand, or the right side of the brain was not talking to the left hand side of the brain?
Yes, so I actually got a copy of the Official Information Act request from Mackenzie Smith, the Radio New Zealand journalist who's been involved in this. So that shows the email train. So it just appears as if they didn't really think about it. They appear to have identified Clearview from that same New York Times article that the podcast was critiquing, and just thought that they might do a test of it. So again, I think it demonstrates that idea that there isn't really a legislative framework that deals with this particular technology, which is one of the things that we've been interested in, whereas there's very strict rules around other biographical and personal details. And like, I think we would definitely say that facial recognition is a very useful technology. Anytime you go through a smart gate or apply for a new passport, you're using that, and that's quite legitimate. But this idea of the public search, either from CCTV enabled cameras or these public search functions, I think is quite a concerning use, and I think the public would be concerned about that. So
just to be clear, there was nothing illegal about what the police were doing. There wasn't what we'd normally say in search and surveillance law. We often think of difference between trespass searches, things where you're infringing on people's common law rights, and we need warrants for those, and everything else. The police obviously do lots of investigation which doesn't need warrants, and that's often perfectly appropriate. Now, they can read the newspaper, they can Google people, and that's basically fine-ish. When does it cross the line? I think that's one of the great difficulties always in trying to formulate when it crosses the line from just the police doing what the rest of us can do. And we can all basically, if we wanted to, cyber stalk people to find out who they are or what they are. And we can all use various Google image programs. When does it, just very briefly, when does it cross the line into something we need to be worried about?
Yeah, I think this is one of the great questions that we have to consider in our research. So is there a social license in New Zealand? Do people think it's appropriate that, for instance, there could be a facial recognition CCTV camera on Lambton Quay that can take your image and put it through one of these databases? So I don't think we've got a firm view on that yet. And that's certainly something, my point about the social license possibly changing over the last couple of months is something that we really need to feed into our research now. And I think that's our real goal, is what are the legitimate perimeters of the use of this technology. But I think what's definite is that the public would expect that if the police are going to do a trial of something like this, that at least our usual procedures of getting a privacy assessment and involving our Privacy Commissioner are followed.
Yeah, because that's going to be interesting to see in the next couple of months. Already, listening to the radio this morning, the bar owners who are opening up tonight were talking about using temperature guns to determine the temperature of everybody coming in. And I think 3 or 4 months ago, we would have thought this is basically crazy and that people would just not consent to this. but this tends to be almost de rigueur now. The example of a good host is actually to have a temperature gun where you can figure out the body temperature of the people who are coming into your premises. So it's just going to be interesting to see how far that's going to go to what we accept generally about state intrusion. But they're opening today, Dean, because we're now in stage 2, and the bars have had a bit of a delay. But Dean's been doing some thinking, really trying to get a bit of a 1 or 2 word slogan, because I think we're already missing the phrase bubble. My local cafe is still using bubble because it's such a nice way of expressing a thought. And we really had a problem trying to figure out a way of expressing the thought under level 2. And Dean's been thinking about that. The prime obligation is to avoid intermingling, but that just sounds very strange. I wished my students happy intermingling last Friday when I closed off my interview, and I'm not sure that was quite the correct phrase. But Dean's been trying to think how we might summarize this stage 2 and maybe the stage 1, when we're not so much concerned about bubbles, but concerned about something else.
Yeah, we sweat the big issues here, the lexicon, because, you know, as you say, lockdown's a bit stale, but is it loose disassociation? Is it careful commingling? Is it managed gatherings? I'm not sure, and you know, welcome people to tweet ideas on that front. It's clear it's towards business as usual, but not business as usual. So a next normal, and you may notice that I've escaped my cottage on the hill, and that's because, you know, neighbours on one side had landscapers this morning, and neighbours on the other side had builders. And I'm back in old government buildings, only to find that it's freezing because there's a broken boiler, and there is a water blast going on outside my room. But I think the striking thing about level 2, and the PM made it clear in her presser earlier this week, is that it's going to be a continuum of regulation. I myself prefer the rolling mall, I feel was appropriated by the Finance Minister in relation to the budget, but it's the idea that under level 2, there'll be an evolution of rules. We already know that the bars are opening tonight. But is it midnight? I think it were 11:59.
This afternoon, I think they were hoping.
Oh, it's this afternoon. So some people might be listening to this podcast.
You can head over to the Old Bailey afterwards, Dean.
Yeah, absolutely. Well, avoid the hangover. That's all I say. But the other thing is that we know that on Monday at Cabinet we'll be reviewing the rules, and we'll be probably looking to loosen some of those rules. And the gathering size restrictions, the present cap of 10, is under review for Monday and other ones. But the PM sort of signalled that that'll be an iterative process, and there'll be other evolutions and loosenings once the data is obtained of the risk and the practice of the country and so forth. So I think that's really the striking thing about 2 is careful commingling, or managed or regulated, but in a loose and evolving way.
And the interesting about those rules is just observing people the last few days, is that in some ways people were very comfortable knowing what they could do and what they couldn't do under level 4. Well, basically you couldn't do anything, so it was a pretty easy thing. Level 3, people were a bit uncertain, but basically got the point. I just wonder whether the lack of a proper word is really stopping people getting the point of what stage 2 is in terms of what it actually means for people. And I think there's quite a lot of one gets a sense there's a lot of confusion about what can be done and what can't be done. And the obvious big confusion of the week has been a dispute about whether the Prime Minister was right, or whether the police were right, or whether opposition MP were right, or whether Bishop Tamaki was right about gatherings and religious services. And before you start, it's been interesting for me just watching different reactions from different parts of the religious community, some very accepting of the restrictions. Current restrictions. There was one Anglican priest in Auckland ordering shot glasses so that he could minister communion in his shot glasses, which I thought was a very an interesting response to the rules. But others are obviously very resistant, and there's an interesting play going on now between, which is not unfamiliar for those of us who watch the politics of other countries, of trying to set a government against a kind of religious freedom movement. But rather than being focused on that big issue, obviously it's focused on the particular wording of the level 2 orders. So do you just run us through, Dean, what the interpretive issue is and what the resolution of that might be?
Well, and Simeon Brown, the National Party MP, raised this with a apparent expose to say, religious services have always, if you read the level 2 rules, fall within the definition or treatment of businesses and services, which has that 100-person cap, rather than as most people expected, it was a type of gathering, and only permitted if it was a lower risk gathering. Higher risk gatherings of 11 people or more were prohibited. And reading through the rules, I think the only sensible interpretation is that the religious services and worship is a gathering. I've set out in some detail on my Twitter earlier in the week, so I'm working through all the different provisions, but I'm probably not going to bore you with the intricacies of laws 1, 2, 3 type analysis of the meaning of gathering. Suffice to say, I think that it's clear that when the rules talk about services or business and services, they're talking in a sort of a commercial sense in a different way to the religious sense that would talk of religious services. There's a handful of indications in the rules that point towards very strongly, I think, religious worship being a kind of gathering akin to the social and cultural activities, which are also treated as gatherings. And I mean, the interesting thing is religious service isn't marked out for special textual treatment, but as I say, I think all the structural and the textual indications weigh in favour of it being a gathering, falling within the category of a gathering, and thus subject to the 10 or fewer person limit. What's interesting, I think, is that the police, the Prime Minister, when quizzed on this, pointed to some Crown Law advice, not setting out, but saying that she'd got comfort from Crown Law that religious services were subject to the 10-person limit. I've seen floating around a 2-page police operational guidelines, which seem to take a different view. And I think there's some water to go under the bridge on how that's resolved before probably Sunday. Because quite frankly, if that is the advice that's being tendered by the police, I'd respectfully disagree with it, because I think there's very strong indications the other way.
Yeah, and I think just interrupting, because I want to interrupt you. With my point, which is, again, it gets back to this difficulty at this level of being able to explain to people exactly what the purpose is behind the restrictions, and it's a really odd purpose, it seems, from a number of perspectives. But what we know about the virus, what the Prime Minister is saying about the virus, what Dr. Bloomfield says about the virus, that spreads mostly through communities. When it's communities that meet, and the communities do the things that communities do, they hug, or they have tea, or they natter closely together, or they, in this case, pray together. And it's a very strange thing to explain to people who think they're doing the most natural human thing in the world, praying together or worshipping together, that somehow is exposing them to a particular added risk. Whereas clearly Dr. Bloomfield and the Prime Minister on the page, looking at the data from overseas, this is the kind of activity that actually spreads. And then you've got some crossovers. There's clearly bars, at least in Wellington and I think parts of Auckland, down Courtenay Place, are a kind of community gathering. Certainly later on Friday night, it's all a bit of to your phrase, a rolling mall of people, frankly. And at some point, the bars are providing a service, but at the other point, they're bringing a community together. And at some point during the evening, things cross over from service provision to a community. And I suppose that's what the drafters are really struggling with in this work.
Yeah, and I think I read the rules with that very sophisticated rather than blunt purpose. It's not just about regulating the size to prevent the spread or the transmission. It's about trying to minimize the risky behavior, and that's why the mixed veggies rugby team can't do a full rugby training, because there is a bit of cuddling going on arrival, because we're a great big family, but because of that close interaction, and the PM and the Director General have been very clear that in religious worship, it's more than just sitting like a statue in rows and pews. It is a high risk area for that type of transmission.
But then again, the people have argued, well, let's look at what's going to be happening at X bar down on Courtenay Place tonight. the man who was explaining his rules on national radio this morning did say that they would definitely have a no snogging policy. It's just not, and Kim Hill immediately said, well, exactly how you enforce that, and he kind of chuckled. So there is obviously a problem with this virus in terms of, it's easy to explain to people what to do at level 4, a little bit harder at level 3, but at this level, it is really difficult to explain the rationality behind some of the, not the rationale to stop the disease, but the choice of particular words or the sorts of gatherings that are permitted or not permitted. The limits of what the law can really do, I think.
And can I add something on the rule of law, because I think it shows a different expression of the rule of law here, where we've got a very rule book and rule-based type approach going on, and that's the idea that the rules are independent from the creator and the enforcer, and so we've got to the PM's framed sort of the purpose and the thinking behind the design of the rules. The police on the other side have taken a different interpretation of how the rules might be applied, and that might be subject to revision in terms of greater reflection. But the importance is that independence of the rules, and it's the rules which rule rather than the wishes in the background of the creator.
But ultimately, if we can't articulate the reasons behind the distinctions the rules are making, that also has a problem for the rule of law, because people quite rightly are saying, why are these people able to do whatever they're doing down Courtney Place and I can't go to my church?
Absolutely, and that goes to the sort of the extent to which rules change behaviour and create social norms and things like that. Powerful rules are rational rules, and ones which have a high degree of social license inconsistent just erodes that.
And so moving from the bars of Courtney Place to the other end of town, back to our part of town, we're lucky enough to work just across the road from the High Court. Again, when Mr. Borrowdale had his action, Zine and I were imagining we might do a live court report in the foyer of the High Court describing exciting action. Dean, I haven't seen any real action on the Borrowdale litigation this week. Have you been able to, anything on the rumour mill?
Still very much kicking down the road, so very little report. I understand an amended statement of claim has been filed as per the timetable I think that we talked about last week. The indications seem to be that it might be a fatter claim, so it might build in some extra layers of the Bill of Rights, picking up on some of the things that we've talked about here in terms of whether the Director General is acting under dictation, and problems, some of the implementation problems. But as we said last week, that creates a sort of very, very much a fatter and more richer challenge, but it also procedurally makes it, it requires more evidence and more time. So I think the Crown's defence is not due till next Friday, and another case management conference in early July. So we're watching that space. I hear a little bit of chatter about possible intervention to other people coming into the claim, whether that's going to be allowed or going to arise, be allowed, we'll see. I think also the other interesting thing, I'm hearing a little bit of chatter about the legality question potentially being raised as a defence in criminal prosecutions. I think that's the one which is going to be really hard. Well, it's going to be important because that's, as you said, where the rubber hits the road, where there are legal sanctions which have been imposed on someone in the light of the earlier level 3 and 4 rules, and their ability to collaterally challenge the legality of those orders. So not much to report on that front on the courts.
One of the interesting, and Nessa might want to jump in, I'm not sure, but one of the issues is just on that criminal charging thing, what they've actually been charged with, these people, whether they've been charged with violations of the orders or whether they've been charged with associated miscellaneous offences, and whether that will sort of muddy the waters in terms of the collateral challenge. That you might be charged under the Health Act, you might also be charged with disorderly conduct or some other one of these very nebulous offences.
Yeah, I mean, I'll just jump in there quickly. I think there was a sentencing yesterday, for instance, of somebody who one of the charges was one of those failing to obey the order, but also some ancillary charges. I think of vehicle offences and that. But I agree, Dean, it would be absolutely fascinating, and I think this is something that we've raised before, if there was some sort of a legality challenge, because as I think you led off with this morning, Geoff, it is where the rubber hits the road. If we have a considerable number of prosecutions and even people who have served sentence of imprisonment for these offences, that is really where it hits.
And a criminal offence is not to be sneezed at all, is it? In terms of it being, if you have a criminal conviction, you have a criminal conviction. And I think all the people on this podcast don't want to have criminal convictions. Lots of people out there don't want to have criminal convictions. Even if you're going to get a slap on the wrist in terms of the sentence, it's still a big deal that you have committed a criminal offence, and you have to declare it for all sorts of purposes. We take it very seriously in our system, so I'll be interested to see how that all works out. Maybe we'll have some more next week, and we can do some more thinking about that. Just moving on along to Eddie, who's going to just talk about a bit of a triumph, I think, in terms of the select committee process. But just to round back on Eddie's very constant theme in these podcasts, that one of the really important parts of the rule of law is accountability, and making sure that accountability mechanisms are working. We were very concerned, like lots of lawyers and lots of just New Zealanders, about the speed through which Parliament moved last week in terms of enacting the new statute. That's been done, but there are some developments, Eddie, which actually everybody who's listening to this can participate in, as well as us four. Eddie?
Yeah, absolutely. There's you'll recall that we had I think, quite legitimate grumble last week about the speed at which the Public Health COVID-19 Bill Now Act went through Parliament, and there was no select committee process. One of the things we suggested, and I think I closed with this last week, is that it would be great to have some post-enactment review, send it to a select committee to have a look at. And then I said I didn't think it was probably going to happen. Within 24 hours of saying that, in fact, that has happened. And David Parker has, the Attorney General, slightly odd that it came from the Attorney General, by the way, rather than the Minister of Health doing this. But the Attorney General has referred the Act to the Finance and Expenditure Committee for an inquiry to report back to the House shortly before the Act is required to be reviewed, because one of the safety mechanisms that did get into the bill is that it does need to be reviewed every 90 days. So just before that, there will be a report back from the Finance and Expenditure Committee, hopefully suggesting some changes and tweaks around the edges. I think we've all said that substantively we think, in general, it's a pretty reasonable bill, but there are absolutely some things to be improved
So just
that should have been improved.
Before we talk about perhaps just some of those points or what people might submit on, just in terms of this committee, which seems quite a weird committee. When I first heard about this, I think this is a very, very strange committee. Not only is it a bit odd that the Attorney General has been running this bill, not that he's necessarily done a bad job, but it's just seemed to me that amendments to the Public Health Act should come, or the Health Act should come from the Minister of Health. But that normally one would expect this to go to the Health Committee, or perhaps go to the Justice Committee, which has sort of expertise in some of the search matters, for example, or to go to the Epidemic Response Committee. And none of those options were taken. So why are we going to a committee which is normally about really just financial matters and which has a role in supervising the budget rather than supervising the police?
My understanding is basically that it is a large committee which has representation from most parties on it, and it would be all, I think with the possible exception of ACT, because poor David Seymour can't go and sit on every committee in Parliament, which he'd have to because he's the only ACT MP. It's seen as prestigious. The Labour Party saying it will give up one of its seats to a Green representative, so the Greens can be on there. It has a lot of senior MPs and a lot of lawyers on it to scrutinise these sort of things, because maybe it's a health issue, but it's also a law enforcement issue, as you say. Justice may have been a more logical choice, but it isn't seen as having the cachet or the expertise, slightly oddly, that Finance and Expenditure does.
Just on the technical side of things, it's quite a short period though, right, in terms of submission. So if people want to say something about this bill, they've got a relatively short time to actually write about it.
Yes, so if you want to make an oral submission, if you want to appear before the committee, it's basically 2 weeks. They're due on Sunday the 7th of June. If you want to only have your say in writing, you have 3 weeks longer. That's due on Sunday the 28th of June. And you can go to parliament.nz, the Parliament website. Very easy to follow the links there, and you can just fill in a web form. It's as simple as that. And I've seen people make submissions on acts. You can simply say you support it, you think it should be repealed. It's easy to have your say, and this is a really important thing, so I think that you should.
And one of the effects of this committee, and I might be overly exaggerating this, is the big controversy in the bill now really is on the entry power, or was on the entry power last week and continues this week. And one of the instructions is just not to review the actual statute, but as I read the instruction to the committee, it was to review the performance under this act. So not only is it going to be looking at what the act says, which is what normally a select committee would do in terms of legislative review, but it's also going to get some evidence, one would imagine, from the police, exactly how they've used this search power. Did they in fact go on to Marai? What processes they really used when they were considering going on Marai? Or did they use the power at all? And I think there was some evidence that over the last weekend they didn't use the power at all. And that Mr. Costa, the police commissioner, was requiring things to be referred to him before in fact it happened.
Yeah, and my understanding is that the police commissioner essentially said that if you want to use it, you have to call the commissioner's office first. And this is an operational thing rather than a legal thing. So that might not give people the level of certainty that they might like. But also you can't understand enforcement and policing or administrative action more generally without looking at the operational way that things work rather than just what the law says.
And so just putting on my legislative design hat here for a second, there are two things here. One is how you design a statute, what you can put in a statute, and secondly, how you can operationalize the statute and what the incentives that are set up for by the design of that statute. So I'm sure there will be people who will submit that this is a draconian power, that it's wrong to have warrantless searches of people's houses and warrantless searches of Marai. But I think also useful, and I'm sure the police are doing this now, it'd be very interesting to find out what they actually did, how they used this power, because the account that the police commissioner gave was very similar to the one that Nessa gave last Thursday, that this really was an emergency power, that it was designed for situations where there was a high-risk gathering with high-risk, probably individuals relating to COVID, that they needed to do something, that it was ridiculous, would be ridiculous to go and get a district court judge or another certifying officer to agree to a search. But it'll be interesting to see how this works out. Be interested to see this is another layer on top of it, something you can't put into a statute, that a select committee will look into how you're using a power. But it seems to me a very real constraint from a Wellington perspective, what might be, whether it's a real constraint in Porirua or in South Auckland, where there are real concerns of where communities might be concerned about police powers. I don't know, but from a Wellington perspective, it seemed like a significant handbrake on the police using these powers. The second thing, Eddie, to talk about is we've seen a lot of documents coming out of the government in the last week or so about COVID-19 and the government's response. There's been some fantastic journalism, I thought, trying to set out exactly what happened in that really chaotic time in March, when the government went from not doing very much at all, frankly, to shutting the country down in a period of days. But equally, as there always is, there's been some criticism of dumping, that people felt that somehow there was an information overload, particularly on Friday afternoon. Again, that comes back to your accountability thing. So should we be worried about the fact that it all came out on a Friday afternoon, that there's lots of documents, or is that missing the real story, Eddie?
I think it's a yes, but about being concerned, not optimal. Most of the people running comms for government used to work in media. They know how media works. They know that the Friday document dump is a thing. It's been a thing for years, and that it makes things difficult for media. Whether media can change the way it works to diffuse that is a separate question. They knew that media would be annoyed, and media were annoyed. And this was accompanied by some unfortunate comms strategy that leaked out on that afternoon as well. We can just dismiss is not a phrase that a government that is trying to look transparent would ever want to be
slightly
said
better than let them eat
public.
cake as a government slogan.
Dismiss them and let them eat cake. I mean, we could combine. We
or
could
give
combine
them cake
the two.
while you're dismissing them.
Yes, cake or death. So that is suboptimal. But the substance of what is released, I think this isn't something that we should lose sight of as we complain about the way that this was done. It gave us this fantastic picture of how government, all the way up to cabinet, responded in those first weeks of the COVID crisis. As Geoff mentioned, I think the two that I saw were very good long pieces from Mark Dalder at Newsroom and Matt Nippert at the New Zealand Herald, using that information that was in that document dump to tell a really amazing story. And what I think is important to note is in almost no comparable countries would journalists ever be given access to those documents in essentially real time. It would be a decade, or sometimes I think 50 years, before cabinet documents in the archives are released. In New Zealand, the practice is very different. Cabinet papers have regularly been released in New Zealand for years, across governments of all political stripes. And this just doesn't happen overseas. You would not see it in Canada. You don't see it in Australia. You don't see it in the UK. In the UK, they're still trying to not release their modelling on COVID. This release of cabinet level documents really is extraordinary. And there are things about our official information regime that absolutely need fixing. One of the things that was shunted before COVID, and I'm sure will be even more shunted now, is a potential review of the OIA. I think that still needs to happen. But we should, despite that, be aware of how extraordinary the openness at that level of cabinet decision-making is in New Zealand. And we've got a really good example here, even in the middle of a crisis.
Yeah, like there are some redactions, and there's some papers we don't have. Like famously, we still don't have the Crown Law legal advice. That was resolved by the Speaker, I think, at the moment. The Speaker just simply refused both warring factions. On the one hand, he refused David Parker's attempt to send the question of whether the Simon Bridges-led committee could subpoena the document. But on the other hand, he said quite bluntly that no legal advice could be disclosed could be summoned by a select committee. And that just seemed to some of us maybe a bit too absolute, because in New Zealand, one of the features of the Official Information Act, of course, is that legal privilege is not an absolute ground. There are no absolute grounds in New Zealand Official Information Act. What there are good grounds, and then there are grounds that will normally be persuasive, and privilege is one of those grounds, but that there can be an overarching public interest. And so it might have been useful to have it might be useful in the future to have a privileges committee that actually sets out how select committees might go about assessing that balance. Because we talked about the importance of legal advice. Some of us are maybe a little bit more skeptical about what legal advice should always be not disclosed by the government. But it would be great to have that resolved in the future, perhaps by the Privileges Committee or by Standing Orders Committee in the future, because there does seem to be a bit of a gap in the procedure. But like Eddie, I was quite impressed by this. And when you read these documents, you read the stories, one's getting the sense of me. I think obviously in the future, we're going to be looking back and saying, what were people doing in January and February? Why weren't they doing more? Why weren't we passing this COVID statute in January? I've seen one person, an email correspondence I've seen, said, why weren't we doing that? Well, because really none of us were as focused perhaps as we ought to have been on the fact that there was this pandemic coming. I think we work in a sector which maybe wasn't as focused as it could have been either, in terms of what does impress me about these documents is it's kind of like going to a hospital in New Zealand, casualty hospitals we've been with our children, that you can sit around for hours and hours. Nice people will look after you a little bit, and you get very frustrated because nothing's happening. But if there's a real emergency in that meeting room, suddenly in the emergency room, people come from everywhere, doctors and nurses and anaesthetists or whoever else turn up immediately to do the work. And that's the impression you get from these documents, is that, yes, maybe the government was a little bit slow, like all governments were, but once the shit hit the fan, basically, people turned up. That's the impression I get from these documents.
And this is something that someone who's been a critic of the way that the New Zealand Public Service works over the past 20 years, Sir Geoffrey Palmer, our colleague at the law school, put out an op-ed praising the public service response to the rafters, and coming from Sir Geoffrey, I think that's really notable.
Yeah, it's no question, but I think there's still going to be questions asked about the response and whether we could have done things better. And I think inevitably, and I think the Prime Minister's even almost said this, is inevitably we're going to be heading into some kind of big scale inquiry, because that's the way of New Zealand, that's the way of things in New Zealand. But the good thing is that we're probably better off than many other countries moving into this inquiry. We actually have quite a lot of information at the moment. So Dean, just going to finish off the committee, because one of the starring roles over the last couple of months has been Simon Bridges in the Epidemic Response Committee. That committee has been through several phases. At one point it was sort of much must-watch lockdown TV, and it's not anymore. Partly because Parliament's come back, partly because people have got on with their lives. People don't want to watch select committees for that long, but they were, I thought, great at the beginning. But what's happening with that committee now, Dean? Mr. Bridges is obviously concerned about some other stuff this morning, probably, and in fact is not chairing this morning. We're recording on Thursday morning, but what's going to happen with that committee, Dean?
And this might actually be one for Eddie, but I can say that I may have got a little bit of hot water by reading the tea leaves on Twitter yesterday and suggesting that the committee may have run its course, because it seems to me that the Labour government's messages to ministers that now that the usual processes are returning, the ministers should decline invitations to tea before the committee. You know, we can debate where its time has come, but I think that the reality, when you look at the politics in the House, mean that its days are numbered. But Eddie, do you have more to say?
Just that, as Geoff said, it's been in a way depressing and in a way reassuring, a slow slide from sort of quite constructive forensic engagement with the government's COVID response back to normal partisan bickering. We saw some moderately silly stuff yesterday and the day before, with the Treasury Secretary being ill and the chair of the Epidemic Response Committee saying that it was deeply unacceptable that she hadn't showed up, and she was sick and miraculously showed up literally one day later. So trying to make mountains out of molehills. Again, we're back in normal partisan territory here, and I think it's coming to the end of its useful life as a body dedicated to COVID. But one thing we might want to think about, looking at that good constructive stuff in the first few weeks of this, of whether a standing committee looking at general government accountability might be somewhere we want to go. You might think there's a government and administration committee. You might think that could do it, but in fact, that is dedicated to the most boring possible sort of administrivia of government rather than the big questions of governance and administration. So something maybe to think about, whether there's any value in not subject matter based scrutiny committee.
And obviously the Americans do this sometimes poorly, but one of the differences between our system, obviously, and the American system is that Congress often sees itself more as an oversight body than probably at the moment a legislative body. A lot of the focus in select committee work has been on their legislative focus. That's probably when they get the biggest role. In fact, they spend quite a lot of their time doing oversight work. It's just often that's not particularly covered unless there is something particularly controversial going on. So, for example, the Radio New Zealand estimate hearings got very much covered last year because of the controversy over meetings at Astoria. But typically we don't tend to cover that stuff. I'm not quite sure why. I think some of that's really important, and maybe that might give some journalists a bit more of a taste for looking a bit more deeply at some of the performances of the ministries. The other thing I'd just say is that I thought that one of the things that was interesting was the way in which officials were being treated by the committee over the course of the committee. That the beginning, very much there was a cooperative mode. At the end, not only was there some bickering between politicians, but there seemed to be some effort to bring in the public servants into that bickering, which I think is a difficult thing.
I'd go further, Geoff. Not just difficult. I think it's inappropriate to have that sort of badgering and trying to bring people into what should be disputes between politicians. It's not good for the neutrality of the public service.
So we're going to, as we promised, we'd do shorter. We actually haven't been that much shorter. What we're going to do next week is, rather than doing a roundup of everybody's what we're going to talk about next week, what we are going to do next week is each of us, hopefully with some of the colleagues who have appeared with us for the last 6 weeks, we're going to come back and see what we think 2 months into COVID-19, what the legal response has been, what the big themes are, what the really important news has been, and what we can learn for the future. But we'll focus on that stuff next time. I want to thank Nessa, Dean and Eddie once again for some great insights, and again thank any of you who are still listening or watching to us after this period of time. We find the stuff really interesting. We hope you guys are still finding it interesting. Lots to discuss, lots to learn about New Zealand government still from the COVID-19 response. So until next week, it's goodbye from me and goodbye from all of them. Talk to you then.